During opening arguments in a civil lawsuit here in New York, if the defense attorney makes arguments or makes a comment that I think is improper, can I jump up out of my seat and say, "Objection, Judge, that's improper"? You want to know the answer? Come join me for a moment as I share with you some terrific information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney practicing law here in the state of New York. The answer is, I can. Should I do it? The answer is maybe not. You want to know why? During the course of trial, each side has an opportunity to make opening remarks, and that can happen in an accident case, or in a medical malpractice case, or even in a wrongful death case. Now, after the judge gives preliminary instructions to the jury, he'll then tell me to go ahead and make my opening remarks. Then, after I sit down, the defense attorney will have an opportunity to get up and make his opening remarks. Now, if he says something that I feel is improper, I have an obligation, an ethical and a legal obligation, to stand up and yell out, "Objection, Judge, that's improper." And now the judge will have to rule on whether or not he agrees with me or disagrees with me. If he agrees with me, he's going to say, "Objection sustained," meaning that the defense attorney cannot talk about that issue. If he doesn't agree with me, he's going to say, "Objection overruled," and allow the defense attorney to continue on. But now, here's the question, and it's a strategic one. Should I go ahead and make an objection if it's not a big deal, even though it may be legally improper? The answer is maybe yes and maybe no. I have to make an instant decision when I hear those improper things come out about whether or not I should object. I know that if I get up and yell objection, I'm going to highlight to the jury something that I think is wrong. Now, there may be instances where I don't want to highlight it at that point. Instead, I might want to wait for one of the witnesses that I know is coming in to testify to talk about it and cross-examine him about that issue. So I may decide to wait and not make any objection at all. The other option I have is to go ahead and make that objection, because if I don't, what will happen? What will happen is I might be giving up my client's legal rights. And that would come up if we lost the case and now we go to appeal it. And the higher court, who's now evaluating the legal issues that arose, they may say, "Hey, listen, you didn't make any objection during the course of trial, even though it was opening arguments, and because of that, you've waived your right to now on appeal raise that issue." So it's a very fine balancing line that a trial attorney has to make instantly to determine whether or not to go ahead and make that objection in the middle of opening arguments, or let it slide and then bring it up during the course of the witness's testimony and now address it. So why do I share this quick information with you? I share with you just to give you an insight and an understanding into what goes on in these accident cases, these medical malpractice cases, and even these wrongful death cases here in New York. You know, I recognize and understand you're watching this video because you likely have questions or concerns about your own particular matter. Well, if your matter did happen here in New York and you're not getting bitten up with mosquitoes like I am, no, really, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but you have questions that need to be answered, what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.